Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between, yeah.
Hey guys, come on in, have a seat. Let's get into this court update. Now, without further ado, y'all already know about my copyright disclaimer in my QR code direct link to the X page. Now, let's get into this newly filed update just as of today. So, Milagro Elizabeth Cooper is appearing as pro se in reply in opposition to plaintiff's motion for permanent injunction. And then right after this, I will go over the other court document in which Judge Cecilia Altanaga has granted Clare Locke LLP's motion to appear as Amicus curiae because there was no opposition. There was no response. So I'm going to get into those two documents right now. So let's get started, y'all. Grab your seats, grab your drinks, grab your snacks, and let's get right into this. Okay, so defendant Milagro Elizabeth Cooper's pro se response in reply in opposition to plaintiff's motion for permanent injunction. Defendant Milagro Elizabeth Cooper, appearing pro se, respectfully submits this consolidated response in reply in opposition to plaintiff's motion for permanent injunction. Plaintiff seeks an extraordinary and unconstitutional restraint on protected speech that is unsupported by the record, contrary to the jury's findings and inconsistent with controlling First Amendment law. Now, this is number one, which is introduction in procedural posture. Plaintiff's request for a permanent injunction arises after a jury trial in which the jury expressly determined that defendant qualifies as a media defendant under Florida law. Plaintiff's defamation claim was dismissed as a matter of law for failure to comply with Florida's mandatory pre-suit notice requirement. Despite that dismissal, plaintiff now seeks to impose speech restrictions through alternative theories, effectively attempting to revive a defamation claim that no longer exists. The court retained limited jurisdiction solely to consider plaintiff's injunction request, which does not authorize unconstitutional restraints on protected speech or re-litigation of issues already resolved by the jury. 2. Plaintiff cannot satisfy the standard for a permanent injunction. A permanent injunction is an extraordinary remedy requiring proof of actual success on the merits, irreparable harm, that the balance of equities favors the movement, and that the injunction would serve the public's interest. Plaintiff cannot satisfy any of these elements. 3. Plaintiff cannot show success on the merits. The defamation claim has been dismissed, and the jury expressly found that defendant functions as a media defendant. Plaintiff's attempt to re-litigate media status by selectively citing pretrial remarks ignores the evidentiary record. Florida law applies as a matter of law once the jury made its factual determination. 4. Intentional infliction of emotional distress cannot support injunction relief, and no malicious intent exists. Plaintiff relies heavily on intentional infliction of emotional distress, but IIED cannot be used as an end run around a failed defamation claim. Trial evidence and testimony demonstrated that there was no malicious intent on defendant's part regarding the alleged deep fake content. Defendant was live on air when the video was first brought to her attention. Her reaction reflected genuine surprise and uncertainty. Okay, so we're going to pause right here. Okay? We're going to pause right there because let's go here. Okay, just briefly. All right. So as y'all can see here, this was what was submitted to the courts on January the 17th of 2025. Okay. First impression, as y'all can see here. Now, this is from my X page. If you want to get to this document, QR code right there at the top left-hand corner, and you can scroll all the way down. When you start seeing station head, and I'll show y'all just a second, when you start seeing the station head logos, then it's videos prior to actual trial, which was November the 17th of 2025. All right, so let's get right on into this. This is what she's claiming. Y'all see, pause your screen and read. Now, this is what she submitted to the courts. Now, in my opinion, at the time that this came out, I said, well, wait a minute, something is missing, because it was way more said in this video. Now, this is protected by copyright. When it comes down to fair use, this is protected. Okay, so y'all listen to this.
My God. Do you think this would be AI? This has got to be AI. Because I know this bitch is not this dumb. And who would have been recording?
No, just keep
but
listening.
I don't know. It don't look fugazi.
Okay, y'all hear that?
I'm under no. Let me tell you something. I'm 80 steps ahead of Rock Nation. I'll never post that on my motherfucking page. But I'll put it on my motherfucking Discord, though.
Y'all hear that? Did y'all hear that? Let's go back to this. There was way more said than what was submitted to the courts, as y'all can see here. Okay. Let's even go a step further. Now, let me take this off of the screen real quick. And let's go a step further, because this was still in the exact same.
You know what?
Y'all can hear. Exact same video.
I'm not even going to do that. We have multiple mob PIs. I'm going to let Nigga Girl post it. Because y'all not about to put my motherfucking name on this shit.
Okay, now let's go to the end of the video. And this is what Megan Thee Stallions' legal team deemed as her promoting the deepfake video.
Watch how this post jump. This nigga had this video up for an hour. He got 4.8 thousand views. I just liked it and I tweeted. Go to my likes. Watch how this whole jump up.
Did y'all hear that? Okay, so let's continue. All right, so let's get back to it. So she explained in real time how viewers could access content through a public platform feature. The content remained accessible for approximately 15 minutes and was removed. Defendant openly opposed AI-generated content and stated that if the video was fake, plaintiff should pursue legal action against its creator. Now, there is also a video clip from Station Head of her saying that as well. However, what I just played y'all, all of that was said in the exact same video. So let's continue. Defendant only learned the content was fabricated after plaintiff publicly stated so. The content was already circulating publicly, and there was no intent to deceive, harm, or target plaintiff. These facts do not satisfy the elements of IIED and cannot justify a prior restraint. Plaintiff's IIED claim also fails for lack of specificity in existing content. Plaintiff reliance on IIED is further deficient because plaintiff has failed to identify any specific post, statement, or publication that allegedly supports her IIED claim. At no point in her motion does plaintiff pinpoint a particular post, date, caption, video, or piece of content authored by a defendant that allegedly constitutes extreme or outrageous conduct. This omission is fatal. A claim for IIED, particularly one invoked to justify injunctive relief, requires identification of the exact conduct alleged to be unlawful. Generalized references to online harassment or unspecified social media activity are legally insufficient and cannot support the extraordinary remedy of a permanent injunction. This failure is especially significant here because the social media pages plaintiff broadly references no longer exists. Defendant prior pages have been deleted or inaccessible and cannot be reviewed or evaluated by the court. Now, I want to take a pause here because as this trial was going on, and a lot of us are aware, right? There have been pages that have been taken down, as in banned. And that's what we know. Some of us that know that has been around and has been watching, right? Let's continue. Plaintiff does not identify any surviving content currently available to the public, nor does she explain how an injunction could be fashioned when the allegedly offending speech has not been identified in the reference platforms or defunct. Now, let's take a pause again. As y'all just seen on my X page, some of these audio clips are still available, right? Things that you delete off of the internet is not deleted. Someone has screenshotted, someone has clipped, and someone has access and has posted it on their personal pages or in a group setting. So even though it's deleted, it's not truly deleted off of the internet. So let's just make that very clear. Now, this is my opinion alone. All right, let's continue. An injunction cannot issue in a factual vacuum, and the court cannot restrain speech based on speculation or hypothetical future conduct untethered to an actual identifiable publication. Plaintiff's attempt to proceed without identifying a specific post underscores that the IIED theory is being used as an improper substitute for her dismissed defamation claim. Without a specific post, there is no basis for asserting intent, content, severity, or outrageousness, each of which is required to sustain an IIED claim. The absence of an identified publication also precludes any finding of irreparable harm, as plaintiff has not shown that any existing content continues to cause injury or pose an immediate threat. And then this is number 5. Defendant's post-trial conduct undermines any claim of irreparable harm. Following trial, defendant voluntarily limited her public commentary. She participated in post-trial interviews solely to discuss her personal experience in reaction to the verdict. Defendant did not direct threats, harassment, or commentary towards plaintiff, nor did she encourage others to do so. Even after any gag order was lifted, defendant chose not to discuss plaintiff on her show. Plaintiff cannot establish irreparable harm where speech has been affirmatively limited and no immediate injury exists. Again, there are things that we all witnessed on both sides. Let's talk about both sides, on the defendant side and also the plaintiff sides, right? We all saw the press once trial was commenced, right? And then we all saw once everything was concluded. So as the days progressed, we saw, the press from them entering the court and exiting the court. And then as the final judgment came down, we all saw that as well. So y'all can go back, watch videos. You can go back and look at the actual court documents. It is available. All right, so let's get into this one. This is number 6. Response to Amicus Curiae arguments. Amicus briefs filed in support of plaintiff, including the recent filing by Roberta Kaplan, improperly attempt to reframe protected commentary as harassment and advocacy as non-media conduct. These arguments ignore the jury's findings in misstate Florida law, which determines media status by function, not viewpoint neutrally. Speculation about motive or bias cannot justify an injunction or override First Amendment protections. Okay, y'all see that? Number 7, prior restraint in the public interest. The injunction sought would constitute a prior restraint, which is presumably unconstitutional, particularly where the speaker is a media defendant commenting on public proceedings. The public interest strongly favors protecting free expression and press activity. And then number 8, plaintiff has not met the heavy burden required for a permanent injunction. The request disregards the jury's findings, attempts to revive a barred claim, and seeks to restrict constitutionally protected speech. Plaintiff's motion for permanent injunction should be denied in its entirety. And with this being said, I think we need to go back to the actual jury verdict. I think if we go back to the actual jury's verdict, then that will allow us to have some type of sense of what happened and what was said, because there are a lot of things that has been misconstrued. And so for me, I think it is time for us to go all the way back down to memory lane. Now, this was in November. Okay, so we're going to go back down to November and we're going to look at the jury's verdict. Okay. So let me get that, y'all. 1 second.
Document Tingz, bringing truth to the light.
All right, so let's get right on into, y'all, I'm sorry about that, but let's get right on into, this was what the jury said. Now, this is the jury verdict form. Okay, now this is on count 1, defamation per se. Y'all can see right here. This is what the jury of, when they officially said this, before this claim was actually taken out. But this is what the jury said. Now let's read. Question 1. Do you find by a preponderance of the evidence that Ms. Cooper is liable to Ms. Pete for defamation per se by accusing Ms. Pete of perjury, a felony, by lying under oath in a criminal trial when she asserted that 1, Ms. Pete was a non-credible witness, 2, I could go down the list of all the different shit that was not true, and 3, as was Megan Thee Stallion caught trying to deceive the courts again. This is originally what the jury said. They said yes, as y'all can see. If your answer to question 1 is yes, continue to question 2. Okay, so question 2. Do you find by a preponderance of the evidence that Ms. Cooper defamatory statements caused Ms. Pete actual damages? They said yes. Regardless of your answer to question 2, continue to question 3. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper provided disinterested and neutral commentary rather than advocacy for a particular client or personal interest? Now, they said no. Okay, let's go to question 4. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper regularly disseminated news or information to the public rather than making an isolated or one-time publication? They said yes. Question 5. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper impartially disseminated information rather than acting primarily to promote her own business, product, or services? They said no. Then question 6. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper operated for the purpose of informing the public about matters of public concern through news reporting, analysis, or commentary? They said yes. Okay, number 7. During the time period when the statements were made, Now we're going to skip over this because it's like a repetitive thing. We're just going to go down to the actual question. That Ms. Cooper functioned in a similar manner to traditional news media, such as newspaper, magazines, television, radio, or their online equivalents. They said yes. And in question 8, Cooper should be treated as a media defendant with regard to the statements made in this case. They said yes. So that is count 1, which is defamation per se. So when it came down to the actual defamatory part, as you see here, they said yes. But down here, as we see, media defendant, they said yes. So in my opinion, by reading this, I would think, in my opinion, that this is a technicality where, hey, we are labeling her as a media defendant, which then removes this defamation per se claim, because as someone who is a quote unquote media defendant, you will have to give them a pre-suit notice. But as we see here, this is the original jury verdict when they said yes to her defaming Megan Thee Stallion. Okay. And then that's when we have this court document here. So let me take this off of the screen really quickly. And we're going to get into the actual final judgment. Just to be transparent on everything, okay? So here goes the final judgment. So right here, the jury also rendered its verdict as to defendant's media defendant status, finding that defendant should be treated as a media defendant regarding this statement at issue as a condition preceded to the defamation suit. Section 770.01 Florida statutes requires a plaintiff to serve a media defendant with a written notice specifying the alleged false or defamatory statements at least 5 days before filing a complaint, as y'all can see there. And so this is why defamation was omitted. And as y'all can see there, $59,000 in damages, as y'all can see there. So just to briefly go over that piece. Okay. Now let's get into this amicus curiae. Okay. So when it comes down to the amicus curiae, by default, it was approved. Now, why was it approved? It was approved because there was no opposition filed. Okay, so y'all give me 1 second. Let me get this pulled up for you guys. All right, got it. Okay, so let's go over this order. This cause came before the court on a sua sponte review of the record. On December the 29th of 2025, Clare Locke LLP filed a motion to appear as amicus curiae in support of plaintiff. Megan Pete's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law. You can refer back to docket 270. Under local rule 7.1c, each party opposing a motion shall serve an opposing memorandum of law no later than 14 days after service of the motion. Failure to do so may be deemed sufficient because for granting the motion by default, which as y'all can see here, it has been ordered and adjudged and granted by default because there was no memorandum of the opposing of this order. All right. And that is that. Now, I do have the amicus curiae. It is 27 pages. I may do a separate video reading over that, but until then, I would like to thank y'all for joining and going over these court documents with me. Like, share, and subscribe. I appreciate all of you. I cannot do this without you guys. So I love y'all so much. Now, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I will see y'all on the next video. Y'all have a good one.